Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola Law Firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we'll be discussing preventing and reporting sexual harassment. It's a very popular topic in the news and a very important one. And my guest is attorney Jeffrey Ettenger, and he's a partner with the firm of Schwartz, Ettenger, located in Melville, Long Island. Jeff, welcome to Law You Should Know.
Thank you. I appreciate it. It's a pleasure being here.
And, of course, everyone's heard about sexual harassment. It's been in the news a lot lately, and I know that you and your firm represent employers in all types of employment litigation, including preventing and responding to sexual harassment claims.
Correct.
So what exactly is considered by the law to be sexual harassment?
In its simplest terms, sexual harassment is unwanted sexual advances by a coworker, employer, or supervisor. Obviously, it takes on many different forms under the law, but that is the most basic element of a sexual harassment claim.
And can it just be like a comment or remark, or there must be some kind of physical component?
It can be a comment or remark, but under the law, to establish what they call a prima facie case of sexual harassment, you have to establish what they call severe and pervasive conduct, which means if it's an off comment or a one-time incident, unless it's severe, it's not actionable under the law. Now, that doesn't make it right, and somebody could certainly bring a claim, but to be able to establish and pursue that claim, it would need to be severe and pervasive.
So it's just some kind of comment about someone's dress that someone doesn't appreciate, that would not be enough?
Generally, if it was one comment, one time, it probably would not be enough to establish a claim under the law. But if it's consistent or more drastic, it would be.
Okay, and why is it important for employers to try to prevent these types of complaints?
There are a myriad of reasons why it's critical for the employer. First and foremost, they must protect themselves from potential exposure and liability. The liability for a sexual harassment claim where an employer does not take appropriate action is very significant. The second reason is for the morale of your staff and in general to protect your employees from unwanted advances and harassment in the workplace. It leads to unproductivity. It leads to a lot of creative problems, and obviously it's really bad precedent, reputation and otherwise, for an employer to allow sexual harassment to exist in their workplace.
And becomes a big distraction and could be costly and hurts their brand image.
Could be all of those things, and if it's not handled correctly, most likely it's going to get worse and it's going to cause more problems for the employer. And you're right, if it becomes a matter that the rest of the staff knows about, it creates a myriad of different problems for the employer.
And what can an employer do to try to discourage it or prevent it?
Well, the first thing and most important thing that an employer needs to do is have appropriate training. You need to have an employee handbook, which outlines what sexual harassment is, and you need to have, to the extent you can, employee training on what is sexual harassment. There are a lot of companies that give lectures or audio tapes, videotapes that they can provide to their employees to show them what is and is not sexual harassment. And it's also very important to have a procedure in place for reporting and investigating sexual harassment claims. So an employee who has been sexually harassed knows that they have some place to go to report what has happened, and that the employer will take appropriate steps to investigate the matter and handle it appropriately.
And is it usually the superior of the person who's doing it, or is it usually some isolated department who's may not be buddy-buddy or may not automatically support the the person who's creating the problem?
Well, sexual harassment can come in all different forms. It can be by a coworker, it can be by a supervisor, it can be by an owner. Obviously, it's more severe when it's conducted by a supervisor or an owner, but under all circumstances, the employer has an obligation to investigate the matter and handle it accordingly.
Can it happen to or by an outside, let's say a customer or a subcontractor or independent contractor?
It gets very complicated with that, but the law does state that the employer has an obligation to protect its employees from harassment in the workplace, regardless of where it comes from. So obviously, if it comes from a client or a vendor, it has to be handled differently, but the employer cannot simply say, it's not my employee, I don't control them, so therefore I cannot get involved.
And are those people also protected from harassment?
Yes, absolutely. Clients, vendors, third parties have the right to come to your workplace to work with you in a manner that does not create problems for them. And you have a similar obligation if a client or a third party makes a complaint about one of your employees to investigate the matter and handle it, or you could face liability from that third party.
Are there also federal or state agencies that investigate these problems?
Yes. What people have to understand is that every level of government, there are agencies that are there to protect employees from all forms of discrimination. If you live in New York City, there's the New York City Council. If you New York State, the New York State Division of Human Rights. Under federal law, it's the Equal Employment Opportunity Commission, and most counties, Nassau and Suffolk included, have commissions established to protect employees from harassment. And what those different agencies will do is they will investigate the claim free of charge to the employee, and if they find probable cause to proceed, the matter will go, in many cases, to an administrative hearing, in which case a judge could issue damages. And in most jurisdictions, the person can have legal counsel free of charge.
And regardless of those findings, can someone also bring their own lawsuit?
Yes. Well, there are specific procedures in place for how you can file lawsuits. In federal court, you have to go to the EEOC first, and they give you what's called a right to sue letter, which then allows you to go to federal court. You can go immediately to state court and file an action under New York state law, but you cannot have what they call an election of remedies, which means that you would go both to the Division of Human Rights and to state court. You have to choose one or the other.
Does it sometimes come down to a matter of credibility between what person says they heard and what the other person says they said?
Well, ultimately, within any case under the law, the ultimate fact finder is either a jury or a judge, so it becomes an element of credibility and proof. Obviously, if there's tapes, if there's emails, or if there are witnesses, it certainly enhances the claim brought by the employee. But if it's just the employee and the supervisor or the owner, it could be a question of his word against hers, and it's a question of what the jury believes.
And if an employee, I realize you represent employers, but the employee feels that something crosses the line, should they complain early and often?
The reality is that it's very challenging for an employee because there's a lot at stake for them. But the best thing they can do, if the company has an appropriate procedure, is they should report all acts of discrimination and harassment at an early stage, even if it's minor. Because what they want to do is establish that what's happening to them is wrong and allow the employer to investigate the matter and hopefully reprimand the party that is committing the harassment so that it stops before it gets to the point where it becomes so uncomfortable and awkward that it becomes a corrosive workplace.
And if the employer does react, will that be some kind of defense to them, even if the action continues or escalates?
Well, it all depends on what the employer does. Now, if it's a co-employee that's on the same level or below you in employment, if the employer commences a proper investigation, they can be immunized from liability. If it's a supervisor or owner, the employer is responsible for the acts of those supervisors or owners. So as a result, they may be liable either way. But the better that the employer investigates the matter and handles it and takes appropriate action to stop the harassment, the less likely they are to be liable for the acts.
And does the investigation, can it be just what level of investigation and is sufficient, and who conducts that?
Totally depends on the circumstances of each case. Ideally, you'd like to have a dedicated human resources person in your office to conduct the investigation, which could be interviewing witnesses, taking documents, ultimately deciding what happened, reaching a conclusion, and making a determination with management. If it's a very serious form, they should hire an outside agency, either a law firm or a specific company that handles these type of complaints, and allow them to do an independent investigation and issue a finding. And generally with that finding, they make a recommendation as to what should be done, which would include either education, reprimand, or even termination.
And they'll be protected if they follow the recommendations, because then do they just open themselves up to a wrongful discharge lawsuit from the person who's being let go because of it?
Well, there's risk on all ends for the employer, but there's a thing under the law called retaliation, which means that if I bring a sexual harassment complaint to my employer or to an outside agency, and then my employer takes negative action against me as a result of my claim, that I can file a claim against them for retaliation. So it's almost like a whistleblower claim. So there's risk on both ends. But yes, if the employer takes action against the harasser, obviously there's potential risk there. But they have to make an assessment of the claim, the value of the claim, the credibility of the claim, the evidence that's presented, the severity of the claim, and they have to make a judgment call. In many cases, the employer will choose education and reprimand over suspension or termination. But if it's a severe case and it's proven to be accurate, the right decision for the employer is they have to immediately terminate the employee.
And will the investigation look for patterns, even if there were no complaints, just to substantiate one side or the other?
It certainly could. Ultimately, you're looking for credibility of the complainant. So if there are other complainants or there are other issues with this particular employee, they should take that into consideration.
And if someone is applying for a job or wants to research their company's policy of protections against sexual harassment or track record in dealing with it, are there ways they can do that?
It's a little challenging. In most of these are not public records. If they've been sued, obviously you can do an internet search and pretty much find anything you need on a certain company. But the complaints with the EEOC and the Division of Human Rights are not a matter of public record unless you did a specific Freedom of Information request, which most people cannot do. You can obviously ask in an interview if they have an employee handbook, if they have a human resources department, things of that nature. But unfortunately, there's risk with any type of job, but you don't know what you're walking into.
Do people sometimes post blogs about these kind of things?
Absolutely. I mean, the way that the world is now, you can find out a lot of information about your prospective employer or your present employer by looking at that. But you have to keep in mind that a lot of people who enter those blogs are old employees, ex-employees that do not have a good rapport with their employer, and they're looking to hurt them, so they're going to say some things which may not be accurate.
And this is a slightly different issue, but I'm sure you have to deal with it. Can someone post a complaint on social media and be protected for doing so, especially if they don't do it from their workplace computer?
Most likely, yes. There are First Amendment rights. The NLRB actually has issued many decisions on employee protection of the First Amendment rights, but there are limits to that in terms of your right. It has to be from your personal, and you are an employee of the company, so in some ways you have certain loyal obligations to the company to not make false statements and things of that nature. So there's risk on both sides, but you are protected, and some of those protections are backed by legal precedent.
Okay, I would like to take a short break now. When we continue our discussion, we'll talk about lessons that can be learned from what we've heard about sexual harassment claims at Fox News and other procedures in making or investigating or resolving complaints about sexual harassment. We're talking with Jeffrey Ettenger, and he's a partner in Schwartz, Ettenger, a law firm in Melville, Long Island, New York. And you're listening to Law You Should Know here on 90.3 WHPC and also over the internet at ncc.edu/WHPC. We'll be back in a moment.
This portion of programming on WHPC is brought to you on behalf of the Nassau County Bar Association, who wants you to know about ADR, Alternate Dispute Resolution, which can help you avoid costly, lengthy, and uncertain litigation in court. By resolving disputes through mediation or arbitration, it gives you control over who decides your case. A mediator helps all parties to reach an agreement they can live with, or an arbitrator selected by the parties hears and decides the case. Your attorney can still represent you, but you control who decides your case. ADR is faster and less stressful than fighting in court, and it is a great way to resolve divorce, employment, or commercial disputes. ADR is now offered through the Nassau County Bar Association. Find out more about how ADR can help resolve your dispute by